we should have cleared all these matters before getting the claimant to come online.
It was already 12 o'clock. It is good that the claimant is online, my lord. It is his case. Let him witness how trial goes, my lord. However, while I have listened to my learned friend's submissions on the application, truly speaking, the appropriate way to respond to emotion is by filing a counter affidavit and a written address. My learned friend, who had all these points that he had up until this time, should have penned his voice down rather than making much hay about his fellow colleague in court. He would have penned his voice down, and we would have battled it out, and a ruling would have been given one way or the other. And my lord, while I call this application quite a harmless application, my lord, if the document goes in, when my lord is writing her judgment, my lord can always discountenance. My lord is not forced to look at any document. If at the face of a document it is not what a party says it is, my lord can always discountenance it, not look at it, in fact strike it out if possible. Not for my learned friend to conduct the case of the claimant, so to speak. What is an abuse of court process is within the whims and caprices of my lord, not within counsel. And I will take the exception for counsel, pointing at me like I did a houseboy job. My lord, I did my job. I'm doing my job as a lawyer. And my learned friend should at least know that he is doing his own case, not to cross boundary. If my learned friend wants to take a date for the motion, we will still proceed with today, my lord. When he is ready with his counter affidavit, we would also have our own right of reply to him while we go ahead with cross-examination today. So it is still just stretching the case beyond imagination. So it depends on which direction he wants to go. So, but my lord, I leave the rest to the court. What is important is cross-examination would have to go on today. If they want to go up and come down today, if they want to finish today, let them finish today. Then we can take a date for the motion if possible. If my lord strikes the document out, we will still go ahead with their defense. There's no harm done. This is a give or take in trial. You do your part, I do my part. Everybody goes home happy. So, my lord, I'll leave the rest to my lord to decide. But what is important is cross-examination must go on today. And one way or other, the motion will be heard. We will bring in this document. If they oppose and my lord says, no, this document cannot come in, then it will not come in. But cross-examination has to go on today, my lord.
My lord, I will only say that if my learned friend feels that I cross boundary by way of personal attack, I apologize to my learned friend. But my comment is just to show that, honestly, I do not think this is kind of application that your lordship should be dealing with. I apologize to my learned friend.
Me, I think everything should be done the way it is supposed to be done. There's an application, and the other side is still within time to reply. I always ask the counsel, have you replied? Are you opposing? Have you? If there is still time to reply, I want to say that let the reply come in. So the court will look at it and then know just whether to agree or not.
As the court pleases, my lord, I also reason along that line. But what I plead for my lord is while we wait for the application to fall in line, we can proceed with the business of today.
Which is
cross-examination.
We are ready.
Yes.
That's why we are here.
Okay.
Yes, my lord.
We can go on with the cross-examination.
Yes, my lord.
Okay, then. Where is this? The man has this. Okay, is there? Okay. Cross-examination. Please let somebody tell him that he's still bound by the oath he took. We are going to cross-examine him. Witness.
Sorry, yes.
Good afternoon.
Was I addressed?
Yes, sir, quick.
Yes, my lord.
Yes. We want to tell you that somebody is coming to cross-examine you.
I understand that, my lord.
Okay. We also
I also understand. I understand that I'm bound by my oath as previously.
You were sworn before you started your evidence in chief. We want to tell you that you're still bound by the oath you took to say the truth and nothing but the truth. So help us, God. Yes.
That I swear, my lord.
Very well.
I would point out that this is the ninth time that I've appeared in this court. The first 8 were before it was transferred from the Federal High Court. So I really understand the process.
Okay.
Please, Mr. Quack, today is for cross-examination, please. I'd
Yes.
really like you to focus on cross-examination, please.
I understand that.
Thank you.
Thank you. All right. Go.
Thank you, my lord. Good afternoon, Mr. Quick. I reckon that it's also afternoon in South Africa, where you are.
Sorry, I didn't catch that.
I'm only greeting you. I said, good afternoon, Mr. Quick.
Yes, good afternoon to you.
My lord,
Yes.
may I ask for the exhibits?
Okay.
Hold on.
Let's go and take the exhibit.
So I'll be speaking to Exhibit 1, the employment contract.
Okay.
So my first question, Mr. Quirk, you confirmed that there are only 2 parties to the employment contracts.
So there are only 2 what?
2 parties.
2 parties.
Yes, to the employment agreement dated 25th February 2005. There are 2 parties. That is the first defendant as your employer then, and you as the employee. Is that correct?
I think it's not quite correct, no, because at all times the second defendant was acting for and on behalf of the first defendant.
Okay, fine. That's okay. So, but my question is this. I'm not talking about how the second defendant acted. We will get to that. My question now is that looking at Exhibit C1, the employment agreement, the parties to that agreement are 2. Only 2. The first defendant as your employer and you as the employee. That is correct.
I'm not quite sure what the legal distinction you're trying to make, but the second defendant, the chairman of the company, was he was the party with whom the negotiations were entered into, acting on behalf of the company.
Mr. Quirk, I will implore you to answer the questions that I have put to you and not set questions for yourself. I know what you are talking about. We will definitely get there. If I don't get there, your counsel will get there by re-examination. But I wouldn't want us to waste the time of the court. Just answer my question. Please, who are the parties to the employment agreement? Exhibit 1. Who are the parties? Mention them to the court.
ICO Insurance PLC and myself.
So there are only 2 parties. Thank you.
Yes.
So if you look at that exhibit 1, sorry, C1, why you signed for yourself, it was signed on behalf of the first defendant by somebody. You confirm that?
I haven't got a copy.
My lord, I would like Mr. Quirk to be shown exhibit C1. I don't know how we'll be doing this, but
No, take it. You can show it to him.
can we unbundle this? I hope this will not waste much of our time.
Can you see it?
Can you try put some light on it?
No, I actually want him to see the last page, the signature page. Okay.
So you talk while I show him. You have an idea of what I'm saying. Cancel. Tell him what I'm showing you, so you have an idea.
Okay, that is the employment agreement that you can see. It was part of the document that you have tendered. That is actually your exhibit. So you should know that document. So I'm referring to the last page of that document where you signed and somebody signed on behalf of the first defendant.
These documents we have been asking for copies of these, I think, for many years. I don't know what to say. This document was submitted to the Federal High Court. The original of it, I believe.
My lord, maybe the claimant should be guided at this point. I am referring to a document tendered by the claimant itself, which is already before the court.
In this court?
Yes, my lord. That is the SBC1, my lord.
Okay, because he's saying that it's talking about the Federal High Court.
My lord, the claimant is, I don't want to say, doesn't understand what we are doing here. Maybe my learned friend should guide.
That they have been requesting for the original from the Federal High Court. Counsel, you should be able to say something about it.
My lord, while this is cross-examination,
yes,
I still would prefer if my learned friend restricts his question to his question. Whatever he has, he should direct it to the court. Not that he will tell that the witness does not know what they are doing here. It sounds as if it's child's play we're working on here. The witness has his own issues with how many years he has stayed in court, from Federal High Court to Court of Appeal and National Industrial Court. If he cannot understand the question, he can tell my lord to rephrase it for him. Probably he will be able to understand. We're in cross-examination and we have been doing this for years. So he can always rephrase the question. If he cannot identify that particular, he will shape it again until the witness provides an answer to him. Then we can move on. I think that's the best way to go, my lord.
Come, do we have the exhibit C1? Let's look at it now. Okay. On the signature. Okay, Counsel.
My lord.
We can both see that I don't think he understands what the question you are really asking him. But, this is here in black and white. On the signature page, we have John Michael Quick.
Yes,
signed, and then a witness whom we don't know.
Somebody signed on behalf of the first defendant.
Signed.
There is a signature there.
Signed, and
yes.
then
yes.
Somebody else signed for AICO PLC.
Yes, that's his first defendant. My lord, this is, with all due respect, this is simple. I don't know how my learned friend wants me to ask my questions. I am asking the claimant questions based on the document he has sent. So I rather than my learned friend guiding his client to say that the document being spoken about is the document he has tendered. I don't know. We are not doing skirmishes here. This is not hide and seek.
I'm not.
We are doing a case before the court.
I'm not going to intervene. I'm not going to interject in your contamination. That's exactly what I'm.
Then you won't teach me how I do it.
Yes,
So what I'm just saying is, my lord, what I'm just saying,
Quick.
Mr. Quack,
Quick.
what I'm just saying is that you cannot tell a witness you don't know what we are doing here. As in, the witness doesn't appear to know what we are doing here. That is just.
My lord, I did not say that. I said the witness does not understand what we are doing. Does not understand. And it is clear. You don't understand my question.
Very well. Our time is running. Mr. Quick, please.
Yes.
You remember the 25th day of February in 2005. It's such a long time, but you remember that date?
I recall, my lord, negotiations leading up to that. I'm sure I must have signed. You know, I mean, my signature's on the page. I signed it.
We have seen your signature. You signed it
Yes.
on the 25th of February. Then for AIICO PLC, somebody signed on the same day. I want to believe all of you signed it together.
I imagine that was probably the case, my lord.
Yes, and yet there's another witness. There's another witness who just signed, but we don't know his name. That's what
I would suggest it's probably, my lord, it's probably, if I can just find the relevant piece of paper, it's almost certainly the advisor to look at Exhibit C22. There are papers building up to the signing of the papers. Acting for on behalf of the chairman was somebody called Deji, of the CEO of
talking about negotiations preceding the contract. The claimant knows what he's doing. He understands my question, but he chooses not to answer, but rather to deflect, talking about negotiations involving the second defendant. And if he goes that route, we won't make any progress. Maybe I will suggest humbly, maybe the witness should come from South Africa and come and stand before your lordship physically, so that he can look at the document and not talk as if he doesn't understand what I'm talking about. We are wasting your lordship's time here. It's unfair.
Are you suggesting that the witness signature was somehow fraudulently added, or what? I'm not quite sure what you're trying to drive at.
Mr. Quack.
Yes.
I think it's right I interject here now. Please, he's going to ask you a question.
Now, this question, I'm just thinking that we are taking up a lot of time. You know, after hearing of this matter, both of you will address the court.
Yes, my lord.
Even now,
the document speaks for
if there is anything that counsel knows about these signatures, he can address the court on it.
And the document speaks for itself. But probably there is something he wishes to achieve.
I'm going somewhere.
Which I don't want to.
This is my case.
I don't want to do his case for him.
Because what we have here are signatures. So it's only his own that he signed and he wrote his name. The other one is just the name of the company.
Yes, my lord.
Then the other one has nothing.
Yes, my lord.
My lord, with all due respect,
so that I can just, my lord, with your permission, please, Mr. Quick. He's referring to your first document, your contract of employment with the defendants. He's asked a question on the signatories appearing at the last page. Please don't rush. He would ask you the question again and then answer the question to the best of your knowledge. Are we understood?
I understand. I think that the answer to the question will be found on the last page of Exhibit C22, and it's an email of the same date, 25th of February.
Sorry, Mr. Quick. Please,
And
listen to my question again.
And it will almost certainly be Deji, who is a very close friend of the second defendant. At the time, he was the managing director of Food Concepts.biz. He negotiated the contract in Johannesburg for and on behalf of the second defendant. And I would suggest, given that the email, and he was talking about, and if you read it, it's very, very clear. I imagine that it is his signature next to it. He is the witness.
Are you
My lord, my lord, the witness has not said anything. My lord, the witness is talking about other things that pleases him. He's not answering my question. And my lord, I will say again, the witness is abusing the privilege to give evidence by virtual means. If the witness is before your lordship, he won't be doing all this. But I'll take the question again. Mr. Quirk, my question is this. In the employment contract, which you signed with the first defendant, while you signed for yourself, someone signed for the first defendant. That is on behalf of the first defendant. There is a signature there. You can see the signature. So my question is, do you know who signed the document on behalf of the first defendant?
I believe it was Deji, a very close confidant of the second defendant, Chief Deli Fajmarokan.
Do you know the name?
Deji.
He became a director of ICO in the years following. At the time, he was both living with the second defendant. He came down with another party, and he negotiated in the offices of Phillips Consulting the contract. And if you read it, he was very involved in that, and I believe it's his signature. And I think that reading Exhibit C22 makes that point quite clearly.
I'm sorry, Mr. Quirk. There are two signatures on that document. There is one immediately below ICO Insurance PLC.
Yes.
There is immediately below the name ICO Insurance PLC. Now, there is another one immediately below the word witness. I reckon that the one you are talking about, which is the signature of one Deji, is the one under the word witness.
Well, I would then suggest that the other person that was obviously in that meeting was Niels Potgieter, the psychologist, working for Phillips Consulting in Johannesburg. There are a whole load of documents, and the three of us are talking about it.
Okay, I suggest to you, Mr. Quirk, that the person who signed the agreement on behalf of the first defender, that's ICO Insurance PLC, is Chief Dele Fajmarokan, the second defender.
I don't know. If you're telling me that, I haven't got it in front of me.
You don't know who signed on behalf of the
Well,
first
I doubt it was him because he wasn't at the meeting.
So you don't know who signed?
No.
On behalf of ICO Insurance. Is that what you are suggesting?
I would be reasonably confident that it would have been Deji.
Okay.
He had. If you read all the documents and the negotiations, it is him, and he was appointed by the second defendant,
Mr.
to
Quirk,
handle this matter.
I'm okay with your response. You don't know who signed, but you think it's Deji.
I think it's probably Deji, yes.
Who was that Deji to the first defender?
He was sent down to working in the offices of Phillips Consulting. They interviewed me. They placed an advert in the Economist journal and in an international newspaper. I responded to the advert. I was interviewed by both Feluso Phillips and Niels Potgieter, who is their employment expert, and later interviewed also by Deji and another colleague of the second defendant, who came down to Johannesburg specifically to negotiate this contract.
Thank you, Mr. Quick. I'm okay with that response. So my next question is this. Given all this, you confirm to the court that the second defendant is not a party to that employment contract. The contract is between you and ICO Insurance.
Correct.
Fine. Thank you very much. Grateful for that response. Now, this is very important. You have confirmed in your written statement or note that the terms and conditions of your employment are set out in SDBC 1. I'm just refreshing your memory. You have made that confirmation. So,
yes.
please, I would like the witness to look at clause 4.1.
No. I don't have a copy. We have asked for a copy.
Sorry,
I have not got a copy.
Sorry, before I go to that, I suggest to you that the wrongdoings that you've alleged in your pleadings against the second defendant relate to acts done by the second defendant in the course of his duties and functions as the chairman of the board of the first defendant. That is the picture, general picture that I get from your pleadings.
Correct.
Thank you very much.
At that time, the chairman was the sole executive authority within.
Thank you very much. That's fine.
That's the
acts alleged against the second defendant relate to acts done by the second defendant in the course of his duties as the chairman of the board of the first defendant. He has confirmed that. So, to save our time, my lord, I with the kind permission of your lordship,
yes,
I would like to read clause 4.1 of that agreement, SDBC 1, to the claimant.
okay,
And then I will ask my question. Thank you, my lord.
okay.
So, clause 4.1, under the heading term and termination of the agreement, reads, this contract shall be effective as of April 1st, 2005, herein after the effective date, and shall remain in effect until April 1st, 2008, unless sooner terminated in accordance with the provisions of Article 4.2 below, and is renewable for a further 2 years. So that is the provision of clause 4.1 of the agreement you had with the first defendant. Now, my question is this.
Yes.
From this provision that I've just read, you will agree with me that the 3-year term of the contract may be terminated before its expiration in 2008. So it was agreed that it could be terminated before. Yes.
Of course.
So the 3-year contract is not sacrosanct. Thank you.
Yes.
And I also suggest to you that all benefits and compensation relating to your employment with the first defendant are set out in Exhibit C1. Is that correct?
I haven't got a copy in front of me, but I imagine that would be the case.
No, that is the agreement you had with this first defendant. That is the employment agreement which you have submitted before the court.
Okay, carry on.
What's the question on it?
My question is, all the benefits and compensation pertaining to his employment are set out in that employment contract, Exhibit C1. Because he has confirmed that the terms and conditions are set out in Exhibit C1. I'm only narrowing it down to the benefits. So you confirm that, Mr. Quek?
I confirm that I think you need to read it in conjunction with Exhibit C22, which sets out all the negotiations on all the different component parts, and the two need to be read in conjunction.
Yes.
So are you suggesting that there are some terms of your employment that are not contained in Exhibit C1? Is that what you are telling the court?
I haven't seen the contract, but I know that there were last-minute negotiations, and I can't remember if it was signed whether they were all included or they were going to be included. So that is why it needs to be read in conjunction with Exhibit C22.
I'm sorry. I think I need the court's intervention at this point. I'm getting frustrated when I hear the witness say, I haven't seen the contract. This is a contract that the claimant has tendered. It's not our document, it's his document, the employment contract. So I really will be grateful if the claimant can be shown or can be directed to read the contract where he is so that we can proceed, my lord.
My lord, but I honestly think he has answered the question. I honestly think so.
You say?
I honestly think he has answered the question.
I'm the one asking the question. He has not answered. He said he has not seen the contract.
No. After that, he now said something. No,
What did he say?
After that, he now said something. The court is on record.
It keeps saying, look at
One
something
SBC 22. I don't know what is SBC 22. There are only 16 exhibits before my lord.
There's no exhibit. You mean exhibit C22 in National Industrial Court or while you were still there?
No, that was Exhibit C22 was given into the NIC court.
Okay.
Maybe my LFL
I think it would also have been given into the Federal High Court at that time as well. What a version of it.
My lord,
tell me what is exhibit C22?
it most likely followed the pleadings, the way the pleadings are. You know, there are many documents pleaded. Probably when we didn't tender all of them. We just narrowed it down to about 16. So the one marked C22 in the pleadings is what is probably referring to.
You have the pleadings. Please help us out. The pleadings is before
No, you continue your presumption.
Oh, have him.
No, if you can't go past that, you leave it. I can't help you. It's your presumption.
Carry on.
I've guided you. That's what it is.
This is going to take a long time.
And with all due respect, my learned friend is not trying to help. He's saying it's my case.
No, my lord, it is his case.
You should. Your client doesn't understand what we are doing. My lord, and I say it again. You have a duty to guide your client.
And I have guided, and I have directed the court to what his mindset is about exhibit C22. It's in the pleadings. If my lord wants me to go through his statement, and open C22, probably I can help in that regard. But I would not help him to ask questions. If he cannot move past the question, he should tell the court. I wouldn't. He asked a question, the witness answered the question. Yes, and you should read it in conjunction with SBC 22. If you cannot move past that, he should tell us. That's why I said the witness has answered the question.
Because personally, I can't move past that one.
As the court pleases.
I've been looking at, all these exhibits. We don't have.
My lord, I will take it my own way if that is what my learned friend wants. Mr. Quirk, please tell the court what is Exhibit 22 that you referred to.
Exhibit 22 sets out the negotiations. I'm going to read it. Deji, first page, it said, thank you very much for supper last evening. I thoroughly enjoyed it and you have a wonderful family. I am greatly concerned that as it stands, I am not going to be able to sign the contract.
Sorry, Mr. Quirk. We need to know the document before you may read, if at all you will read. My question is this. There are 16 exhibits that you have tendered before this court.
This is Exhibit C22.
I'm sorry. The exhibits are numbered Exhibit C1 to Exhibit C16. So there is no Exhibit 22 before the court. So please tell the court, which of the exhibits C1 to 16 are you referring to, please?
The before submitted to the Commissioner of Oaths and the Notary Public here were exhibits C22, 23, and 24. I have no reason to think that they were sent in triplicate up to Lagos, and if they are not in the court proceedings, then they should be.
My lord, humbly, I'm forced to suggest that my lord should terminate these virtual proceedings and request the claimant to come before your lordship and give evidence. I mean, the indulgence is being taken for granted. So if the claimant is here, he will be able to ask his counsel to, or he will be able to show what Exhibit C22 is, and then we can move forward, my lord.
Counsel, you can assist the court. He's talking of Exhibit 22. The court keeps on going through the list of
Thank you, my lord. Thank you, my lord. I think
we have the one before me even ends at 14. Yes, that is enrollment of other court of appeal.
yes, my lord. My lord, we have up to Exhibit 16. That's the schedule I submitted. Yes, that's the schedule I submitted. I can still afford the court my copy. I think what will better guide the court.
You can read out Exhibit 22. Let us.
No, my lord. That's what I'm saying. He's following a pattern in the pleadings. Okay. So what would help the court best is the document. Pleadings. The document he's reading there. What is the heading? What is the heading of it? The so-called Exhibit 22. What he is reading there. It will help us identify which of the documents that was tendered so that it will help the court get better traction of the case.
Okay.
Yes, my lord.
So, Mr. Quirk, the Exhibit 22, what is the title of Exhibit 22?
It is headed up Exhibit C22. The top line is deji@foodconcepts.biz. dej008@yahoo.com, and it is a letter that I sent to Deji, and if you look at the content of the letter, it is I'm going to read it. I think it's important. Deji, firstly, thank you very much for supper last evening. I thoroughly enjoyed it, and you have a wonderful family. I'm greatly concerned that as it stands, I'm not going to be able to sign the contract. Attached under this email is the history of discussions pertinent to the contract and agreements reached. The main purpose of this trip, this was when I was went up to Lagos in January 2005.
Going to sign the contract.
The main purpose of this trip was to agree this contract.
Is that it's not going to sign the contract.
No, my lord, that's not the issue, my lord. The document is reading. Apparently, it's not before the court, and there is no point wasting our time. I mean, I know my case, except the document is with them and they didn't bring it to court. The document is not part of these proceedings, my lord. I am so certain. After listening to what he has read.
Now, I still have about 6 matters or 7. Maybe we could stop here.
As the court pleases. And like I said, my lord, it will be better if the claimant comes physically before the court, so that we can do all the skirmishes face to face.
My lord, let me object to that.
And save my lost time.
Let me object to that application formally. Since he has made this application 3 times. My lord, this man standing there is almost 92 years old. This man has been on this matter for about 20 years and he has been frequenting Nigeria. His health condition as at now would not permit him to travel. My lord, granting an application for virtual hearing is the best thing you can do to this claimant to voice his opinion, to voice
Granting what?
Granting an application for virtual hearing, which my lord did, is the best solution my lord would have given for this claimant.
But now we are not understanding.
My lord, it's about not everybody's not everybody wakes up in the morning with a clear mind. My lord, asking questions is about either rephrasing and rephrasing. If you stick to one and you keep getting the same result, you can't really push it. So if you cannot change the dynamics of his question, abandon some, ask some, come back to those ones.
I'm sorry, my lord. My learned friend will not teach me how to answer my
on my feet.
But
even if I cannot tutor my learned friend on,
you cannot. I am your senior. I am sorry.
Good.
You can't do that.
Even if I cannot tutor him about the case,
You cannot.
what I will continue to do is to object to any application that virtual proceedings should be terminated. Thank you.
Now, counsel.
Yes, my lord.
Can you do me a favor, personal favor? Can you, before the next adjourned date, because I'm stopping now.
Okay.
Before the next adjourned date, find out all these things. Because, you say he has been here in Nigerian courts for almost 20 years.
Since 2006.
He may not remember all these things.
True.
But when you calm down and talk with him, let us know what he's talking about.
Very well, my lord.
He said, as Exhibit 22, where somebody said, he called him and he started reading what they wrote. Find out what it's all about.
I will, my lord. I will.
On the news day.
I will.
And tell him when he's answering. For example, when it goes to reading of all those things,
Yes.
it has to come slowly.
Very well.
So that we will all follow. Everybody will follow what we say. I'm so sorry that I have to stop.
My lord is understood. Very much.
You remember when you at the court granted the Zoom hearing and all that, because I know what it is. Just from here to South Africa, I know what it is.
Thank you very much for your
coming back.
My lord, may I also
but you have to help us.
I will do my part to help. My lord, may I apologize on behalf of my witness, if he had done anything to have slowed the court down, and my humble self, my lord. Sincere apology.
But my lord, we are grateful for the course direction. I will only add that perhaps my learned friend will obtain certified true copies of all the 16 exhibits and properly mark them C1 to C16 and scan them to the claimant. Ask the claimant to study it, then they have a meeting where they discuss it. So that next time we are here, if I'm saying exhibit C3, he knows. If I'm saying exhibit C2, he has read it, so that we can make progress. We are grateful to the court.
Yes. Okay. But questions?
My lord, patience has logged out.
Questions? When are we coming back? Are you all right? You don't do this. What happened? Yes. 28th January.
My lord, 28 is convenient for me.
Okay.
I'm sorry, my lord. 1 minute. It's convenient, my lord.
Okay.
We are grateful.
Okay. So at this time, and at the instance of the court, This matter is now adjourned to the 28th day of January 2026 for conclusion of the cross-examination of CW1.
As the court pleases.
Very grateful, my lord. Very grateful.
Yes.
The case of Victoria, I don't know if I can also take my learned friend from security. If I can also take advantage of my own stage too.
Oh, don't allow people who flag seniority like that to intimidate you.
No, no. That's
Please. So you call your client immediately and tell him why we have. Okay. All right. So what are you talking about seniority for? Okay.
I know that. I don't know if I have any.
Okay.
I doubt if I. Please, I know I've put in at least 2 decades.
That's good.
This one, but then I just learned that first thing one class National Pension Commission. I'm registered for school of both college.